All right, welcome back to the Daily Facts, and we're going to get into part three of the Carter Page document where he is suing several people. So let's get right into it. The FISA warrants were unlawful, federal laws and procedures violated. To obtain these unlawful warrants, the defendants, known and unknown, violated numerous laws, rules, regulations, policies, and procedures. To surveil an American citizen, the FISA requires that there be probable cause establishing two elements. First, that the person is acting on behalf of a foreign power, and second, that the American citizen is engaged in their capacity as a foreign agent in one of five specified activities: current or future criminal conduct, sabotage, terrorism, using a false identity, or abetting someone engaged in these activities. 50 USC 1801B2. Moreover, the FISA requires that certain information be represented to the FISC to obtain an initial warrant and to obtain a renewal of a warrant. 50 USC 1804, 1805. The defendants, known and unknown, failed in numerous and material ways to comply with the requirements of the FISA, made misstatements and misrepresentations, and omitted relevant and necessary information in seeking the FISA warrants against Dr. Page. The FISC also has a set of rules governing the presentation of warrant applications to it. Significantly, one of these rules, Rule 13A, requires the government to immediately correct any misstatement or omission of material fact in a warrant application. FISC Rule 13 provides correction of material facts. If the government discovers that a submission to the court contained a misstatement or omission of material fact, the government, in writing, must immediately inform the judge to whom the submission was made of: one, the misstatement or omission; two, any necessary correction; three, the facts and circumstances relevant to the misstatement or omission; four, any modifications the government has made or proposes to make, and how it will implement any authority or approval granted by the court; and five, how the government proposes to dispose of or treat any information obtained as a result of the misstatement or omission. Defendants, known and unknown, did not comply with the FISC rules, made misstatements and misrepresentations, and omitted relevant and necessary information in seeking the FISA warrants against Dr. Page. In addition, defendants, known and unknown, were required to follow the FBI's own policies and procedures for conducting investigations, criminal and counterintelligence, but failed to do so in numerous and material ways in the investigation of Dr. Page. Defendants, known and unknown, were required to comply with the Woods procedures, dated April 5th, 2001, as amended, which are a set of procedures designed to ensure the accuracy of the factual assertions in an application for a FISA warrant. Each warrant application submitted with respect to Dr. Page included a certification to the FISC that the FBI has reviewed this verified application for accuracy in accordance with its April 5th, 2001 procedures. But defendants, known and unknown, failed in numerous and material ways to comply with the Woods procedures, as explained in the Horowitz report and DOJ letters and filings to the FISC. As a result of their failure to follow these laws, rules, and regulations, policies, and procedures, and as a result of the way they conducted these investigations and the way they misrepresented, misstated and omitted information, defendants, known and unknown, violated Dr. Page's right under the Fourth Amendment to the U.S. Constitution to be free of reasonable searches and seizures. The 4 FISA warrants. The complaint discusses some, but not all, of the material misrepresentations and omissions infecting each of the FISA warrants. The first FISA warrant. On or about August 17, 2016, the CIA delivered materials to certain members of the Crossfire Hurricane team documenting that Carter Page was an operational contact. On September 7, 2016, the CIA sent an investigation referral to FBI Director James Comey and Deputy Assistant Director of Counterintelligence Strzok regarding U.S. presidential candidate Hillary Clinton's approval of a plan concerning U.S. presidential candidate Donald Trump and Russian hackers hampering U.S. elections as a means of distracting the public from her use of a private mail server. In August 2016, then Associate Attorney General Bruce Orr, whose wife worked for political opposition research firm Fusion GPS, briefed Steele's accusations regarding Dr. Page to Andrew McCabe and his counsel, Lisa Page. On or about September 19, 2016, Steele gave 6 reports to the FBI, with 2 of these reports mentioning Dr. Page by name. These reports alleged improper or unlawful communications or activities between Dr. Page and 2 sanctioned Russians with close ties to Russian President Vladimir Putin. Michael Gaeta, the FBI agent assigned to handle Steele as a CHS, said that it was obvious Steele's work was politically motivated. The FBI did not conduct any meaningful investigation of Steele's allegation that there was a well-developed conspiracy of cooperation between the Trump campaign and Russia, utilizing Dr. Page as an intermediary. Pursuant to the terms of his CHS agreement with the FBI, Steele was prohibited from talking to the media about the allegations in the Steele reports. A September 23, 2016 Yahoo News article alleged that meetings had occurred between Dr. Page and 2 sanctioned Russian individuals, according to a well-placed Western intelligence source. Yet the FBI did not ask Steele if he was the source referenced in this article. Instead, the FBI cited the Yahoo News article in the warrant application as independent corroboration of the allegations in the Steele reports. Furthermore, on September 25, 2016, Dr. Page sent defendant Comey a letter denying communications with any sanctioned Russian officials. Dr. Page stated in the letter that he had a decades-long record of interactions with the CIA and FBI. This was consistent with the prior CIA reports provided to the FBI involving Dr. Page, which established that he had such a record. Comey received this letter and distributed it to the Crossfire Hurricane team, including its supervisor, Peter Strzok. In addition, CHS Steele was also found to be offering his dossier to the State Department, conduct that was against FBI protocol, which required Steele to deal with the FBI handling agent solely. Kathleen Kovalak, the Deputy Assistant Secretary of State, met with Steele on October 11, 2016, and forwarded her notes of the meeting to the FBI. During the meeting, Steele admitted he was encouraged by his client to get his research out before the 2016 election, signaling a political motivation. Kovalak's notes also show she found flaws with Steele's allegation and cast doubt on his credibility. On or about September 29, 2016, FBI agent Stephen Soma provided incomplete, inaccurate, and in certain respects contrary information to the information the CIA provided to the Crossfire Hurricane team. When a DOJ Office of Intelligence OI attorney asked whether Dr. Page had been a source for the CIA, the FBI then knew that Dr. Page had been a CIA operational contact from 2008 to 2013, which was the time period relevant to the Crossfire Hurricane investigation and the FISA warrants. Other witness interviews conducted by the FBI were wholly inconsistent with the allegations against Dr. Page, and the two documents still provided by the FBI purposefully withheld this information from the DOJ. In monitored communications between Dr. Page and other CHS, Stefan Halper, Dr. Page repeatedly denied that he had any involvement with Russia on behalf of the Trump campaign before, during, and after his affiliation with the Trump campaign. This relevant and exculpatory information was never disclosed by the FBI to DOJ attorneys. Similarly, statements made by George Papadopoulos and FBI monitored conversations with a CHS that took place in September and October 2016 denied that anyone involved in the Trump campaign was coordinating with Russia. This exculpatory information was not disclosed in the first FISA warrant application. According to a document circulated among FBI, Crossfire Hurricane team members and supervisors in early October 2016, Igor Denchenko, CHS Steele's primary subsource for the allegations against Dr. Page, had historical contact with persons and entities suspected of being linked to Russian intelligence. Yet the FBI did not follow up by interviewing Denchenko before proceeding to seek the first FISA warrant against Dr. Page, nor did the FBI disclose its failure to verify the information provided by Steele in its application for the first FISA warrant in October 2016. Okay, we're going to stop there and we'll pick up on part 4 very soon. Thank you for stopping by the Daily Facts. Do like, share, subscribe, and leave a comment below, and we'll talk again soon. Bye.